Hi, welcome to Tea Time in Olympia. I'm Lucas Miller, and my guest today is Laura Lindstrand, a policy analyst at the Human Rights Commission of Washington State. Laura, thank you for being with us today.
Thanks for having me.
Yeah. So to start with, tell us a little bit about yourself, your background, and what is your role as a policy analyst? What do you do at the Human Rights Commission?
Okay. Well, I'm an attorney, and I decided not to go the big firm route, the business route. I wanted to do something for my community, something in the public interest. So I joined the Human Rights Commission about 16 years ago now.
Oh, wow.
And I started out as an investigator and then kind of worked my way up in the agency to a management position. And I currently hold the role as policy analyst. And it's multifaceted. I do a lot of different things, which makes my work really interesting. I do work with the legislature. I do the rulemaking work. I staff our technical assistance line where businesses around the state of Washington can call in and ask questions about the law against discrimination. I manage our intake unit, and I do media relations and a whole bunch of other stuff. So it keeps me pretty busy, but it's interesting.
Wow, that sounds like a pretty complex job.
Yeah, definitely.
So tell us a little bit more about the Washington law against discrimination, especially with respect to gay, lesbian, bisexual, and transgender people in Washington. How does the law work, and how does it protect GLBTQ Washingtonians?
Okay. Well, the law against discrimination in Washington is one of the oldest civil rights laws in the country. It even predates federal civil rights laws. So Washington is pretty special in that regard.
Yeah.
And the law focuses on the areas of employment, housing, public accommodation, credit, and insurance. So we can look into issues in those areas. And the law prevents discrimination against persons in protected classes. And those protected classes include race, color, creed, national origin, age, disability, use of a service animal, sex, sexual orientation, gender identity, and membership in the armed services.
Okay. Now, I remember that sexual orientation and gender identity were added to that list of protected classes in 2006?
Yes,
I believe
2006.
It was. And now, am I right that gender expression is also included?
Yes.
Yeah.
So the term sexual orientation is kind of an umbrella term that the legislature used, and it does include gender identity and gender expression. So the definition in the statute actually defines sexual orientation as homosexuality, heterosexuality, bisexuality, and gender expression and gender identity. And then it has a further subcategory that defines gender identity.
Okay. All right. Yeah, I remember back when the law passed, there was a bit of buzz kind of in the GLBTQ community that way of framing things was a little bit different than what the community thought it should be, that, you know, they felt that gender identity should be kind of like a separate class.
Right.
And
having investigated this and having dealt with the issues for now a number of years, it seems like maybe it should have been broken up differently, but that's what the legislature did. They had the umbrella term and then had the definition as a subset of that term. So, but regardless of how they set it up, both sexual orientation and gender identity, gender expression are all protected classes. So we're all protected no matter what our sexual orientation is or no matter what our gender identity and expression is.
Okay, good. So what is the Human Rights Commission's role in making sure that that law is applied the way it's meant to be?
So we do a number of things. One of them is community outreach. We do trainings to community groups, employers, and business owners to inform them of what the law is and how they can comply with the law. And then we do community outreach events like this one.
Okay.
And but the bulk of our work is actually doing investigations. So at any given moment, we've got about 700 ongoing investigations that are in those areas that I mentioned before: employment, housing, etc.
Okay.
And we are a neutral law enforcement agency. So that means we do not take the side of either party in the case. There's a complainant and there's a respondent, and we don't take sides. What we do is we gather information, we gather the facts of the case, we try to determine what happened, and then we determine if the responding party violated the law against discrimination.
Okay.
So there are a couple things that have to be in place before we can take a case.
Right.
The event has to have occurred within the state of Washington.
Right.
It has to have occurred within the last 6 months. So say you're fired from your job.
Okay.
You have to have been fired within the last 6 months, unless it's a housing issue. And housing issues, we can look back as far as 1 year.
Okay.
It has to be, it can't be a federal entity, so we can't have oversight of any federal entities like the post office, for example,
Okay.
or a federal employer, or a tribal employer.
Ah.
Or if something happens to you in a tribal casino you think is discriminatory, we don't actually have jurisdiction over the tribes.
Okay.
And if it's an employment situation, the employer has to have at least 8 employees in order for that employer to be under our jurisdiction.
Okay.
So those are the minimum criteria that need to be met before we can even look at a case. Once those criteria are met, our intake department will look at the facts of the case, make sure that it's an issue that we can help with, that we can investigate, and then we'll do a preliminary assessment of the case to determine how that case is going to progress.
Okay.
So anybody in the state of Washington who believes that they've been discriminated against in one of those areas that I mentioned before, based on their protected class, of course including sexual orientation and gender identity, can file a case with us.
If they work at a place that has 8 or more employees.
Yes, exactly.
And they have 6 months from the date of firing or
whatever harm occurred,
whatever
correct.
incident. Okay.
Yeah.
And 1 year if they've been evicted or denied housing.
Right,
Okay.
1 year in housing.
So some examples of, what sorts of incidents you investigate. Like what do you find are the most frequent types of discrimination that people report?
So interestingly enough, our highest category of discrimination is actually disability discrimination.
Okay.
So we get a lot of disability claims. Race, sex, and retaliation closely follow that.
Okay.
Gender identity and sexual orientation actually don't have as many as those other categories that I just mentioned. But it's probably just because the numbers of persons affected might not be as great in the population. For example, we get a lot of sex cases because about half of the population is female. So it makes sense that we'd get a lot of sex cases, but not quite as many persons in the population would feel the need necessarily to file a sexual orientation or gender identity case. So our case numbers of those are lower. But of course we treat all cases the same and we investigate them all.
Do you have any data on, is it possible that maybe there's a lower number of cases because they're being underreported? Is that a possibility?
It is always a possibility that cases are underreported. We have noticed a drop-off of cases in the last year. In fact, our inventory of cases is actually much lower now than it was in prior years.
Okay.
We don't know exactly the reason for it, but we suspect it's the current political climate. That's the only difference we can find.
That people are less willing to report?
That people are less willing to report because they're afraid of being retaliated against. They don't want to rock the boat at the moment. Because people maybe think that their employer can get away with things more in this political climate than they could before.
I imagine it would be tempting to think that the incidence of discrimination has gone down, and maybe that's why
That would be nice.
That would sure be nice,
That
but
would be
that's
great.
probably not the case.
I suspect that
Yeah.
that's not the case.
Okay.
The only, interestingly enough, this is a little bit off topic, but interestingly enough, the only type of cases we're seeing more of now are sexual harassment cases. And that probably has to do with the Me Too
I would
movement.
expect so, yeah.
Yeah. So that's been kind of interesting.
Yeah.
But
So those are examples of the type of discrimination that may be occurring. What sorts of, like for example, is it mostly like hiring and firing, or is there more of like harassment within the workplace, bathroom issues, dress code, that sort of thing?
yeah, we get all of the above. So we get cases running from the very beginning of somebody's employment experience during the interview and application process.
Right.
For example, employers are not able to ask certain questions of persons on the application or during the interview that would reveal that person's protected class. So they can't ask you, what's your religion? They can't ask you, what's your ethnic background? What's your sexual orientation? Are you married? Do you have kids? That kind of thing. And we do still have employers that will ask those sorts of questions. So we get cases that stem right from the very beginning of an employment situation, from the application materials themselves. Improper questions being asked. So persons cannot be asked to reveal their sexual orientation, whether they're married, who they're married to, what the gender of the person they're married to, whether they have children. They can't ask their group affiliations in order to elicit information about what groups people might be, belong to. They can't ask questions about, were you a different gender at some point in your life? Employers can ask questions about names that people have had before in order to do reference checks. But if they discover that somebody had a name of a different gender, they're not supposed to use that information to make employment decisions, only to get legitimate reference checks.
Right. Now, some employers, they can still ask, they can ask you to check male or female, or is that?
They cannot ask you to check male or female. In fact, they cannot even ask you to provide a picture of yourself during the application process, because that would reveal that information.
Right.
So now after a person's employed, in order to get statistical information about the type of workforce that somebody has, they can ask for all of that information. They just need to do it anonymously and not collect it for any employment decisions. And not keep it with the person's personnel file. So it has to be for legitimate reasons and be anonymous.
Now, what about state agencies that ask for that information on, intake forms, or, for example, if you're applying for, some kind of state assistance or something like that, they're still able to ask, what your assigned sex at birth is.
Right. They can ask that information as long as it's voluntary. And as long as it's anonymous and is not kept with your personnel file and your documentation. So it's often important for companies to collect that kind of information to make sure that they have a diverse workforce, and they will often strive to get diverse workforces. So as long as they're collecting it anonymously, as long as it's voluntary, and as long as they're not using it to make employment decisions about a particular person, it's okay.
Yeah, of course, a lot of us noticed that Washington recently added a third gender option to birth certificates in the state. Do you think that's that pattern will be adopted by other state agencies, other areas?
I do. In fact,
driver's licenses and so forth.
I definitely do. I think a lot of more state agencies will start to do that. In fact, the Human Rights Commission is looking at its own forms to make sure that we have all options available to people on forms. So I think it is going to be something that a lot of state agencies will continue to pursue doing to make things more open and equal, and to give everybody opportunities to identify themselves correctly.
Yeah.
Yeah.
I've always had kind of a difficult time, figuring out how to answer that question on certain kinds of forms, being one gender now, but having been assigned a different gender at birth. It's like, which exactly do you want?
Right.
It's kind of interesting to navigate that, and especially for non-binary identified people, there needs to be, a wider range of options. But I'm glad to know that that's the trend.
Yes.
That we're heading towards.
I think it is.
So other than so after the application and interview, what other sorts of what else can happen?
Right. So during employment itself, any type of employment decision that is made that harms you in some way, a demotion, a cut in pay, obviously being terminated, being given discipline, anything that is either a mark against you in employment or affects your pocketbook in some way.
Right.
That's considered harm under non-discrimination law. And if you can show that, say you're 10 minutes late to work a couple times during the week,
Right.
and you're written up for it, and that goes in your personnel file.
Right.
But say somebody else who has a different sexual orientation or a different gender identity than you do, is also late to work, 10 minutes a couple times, is not written up, well, what's the difference there? If you got the same supervisor, you're in the same job classification, you're both doing the same thing wrong, one is written up, one is not.
Right.
So you can pretty much figure it may have something to do with your gender identity at that case. They're trying to get you because of that. So if you can show that people who can be compared to you, who have a similar job, similar same supervisor, similar job duties, that kind of thing, if they're being treated differently than you are, then that is a good place to start as far as building a discrimination case. So we look at comparative information. We see that with age, for example, a lot. People who are older are laid off, whereas people in the same job classification, doing the same work, having the same skills, are kept on. That's a really good comparative analysis there.
Okay.
So when we investigate those types of cases, we look at that type of comparative analysis.
Yeah.
And then, of course, during the course of somebody's employment, the other type of discrimination that they can encounter is harassment.
Right.
And in order for it to be harassment that can be pursued legally, it needs to be severe or pervasive. So in other words, it needs to be really bad. Like calling someone the N-word, that is considered severe.
Sure.
Grabbing someone in their private parts, that is considered severe. One incident of either of those types of harassment is enough to make it a legal issue. And then the other part of that is pervasive. If something occurs day to day, maybe one time isn't so bad. Maybe it's a joke, an off-color joke, or an email or a text message. But if it continues to the point where you're dreading going to work every day because you don't know what you're going to face when you get there, you don't know who's going to be texting you what, or what kind of joke you're going to have to deal with, or what kind of snide comment that's related to your protected class. So if it occurs
Or
and
your
becomes
boss is starting to take notice.
Right.
Yeah.
So if it occurs over a period of time, that can also be actionable harassment. And in the case of sexual orientation and gender identity, of course, name calling, jokes, harassing texts or emails, cartoons that are unfavorable in nature would be considered harassing behavior. Calling somebody by the wrong name or the wrong pronoun on purpose. Everybody makes mistakes. Everybody has to get used to new situations. But if it occurs over time and someone reminds the person who's doing it, no, I go by she, for example, and they continue doing it, and they're doing it on purpose just to get at you, that can be also considered to be harassment.
Okay. All right. Now, what about, for example, workplace dress codes?
So our guidance that we put forth on dress codes encourages employers to have gender-neutral dress codes to begin with. So you shouldn't be having women wear skirts or hose or high heels, for example. You should just have people dressing professionally or dressing in uniforms or whatever the particular job requires. So nothing specific for either gender. And when it comes to gender identity issues, certainly if somebody was born male and has masculine features, but is transitioning to female and wants to present as female, an employer cannot ask that person to dress as a male. If they want to wear makeup and they're transitioning to female or have transitioned to female, they should be allowed to wear makeup, have long hair, do their nails, whatever their gender expression dictates to them that they should be doing for themselves.
Okay.
So an employer who tells the person, well, you're a guy, so why are you wearing makeup, and tells them not to wear makeup, that could definitely be a violation of the law.
I was going to ask, does that extend to someone who's not necessarily transitioning, but who simply wishes to express their gender in a certain way?
It probably does, because the statute defines it to be gender identity or expression. So if somebody wants to express their gender identity in a certain way, probably they're going to be allowed to do that without their employer interfering with that, as long as they're meeting other dress code requirements.
Right.
Being professional, and then presenting to the public in a certain manner, that sort of thing. As long as they're dressing professionally or dressing appropriately for the job, the employer shouldn't have a lot of say-so about how they express their gender.
Okay, all right. Now here's something that I've always been a little bit confused about. I seem to recall reading somewhere that the law does not protect on the basis of perceived sexual orientation. Is that?
That is correct, and that's actually a court case. It was an employer called Fred's Appliance, and one of their employees was a male who was not gay, but who they perceived to be gay, who the other employees perceived him to be gay. Apparently he may have been effeminate or something along those lines.
See, it would seem to me that protecting on the basis of gender expression ought to apply there. In a case where if somebody's gender expression is what leads someone to think, to draw conclusions about their sexual orientation.
Right.
Do you see how that's kind of a...
The court looked at that situation very narrowly, and the court may not have made the correct decision in that case. I think there's a lot of argument to be made. I think had the plaintiff in that case come with just a plain sex discrimination case. I am male and I am also effeminate, or whatever the case was. I think he was
gender nonconforming
or whatever. I think they made fun of him because they thought he was gay, so they joked and teased and did that sort of thing against him.
All right.
But because he was not gay, the court found that under the statute protecting people's sexual orientation, it did not have the language of perceived sexual orientation in the wording of the statute. So because this person brought a sexual orientation case, he lost. Had he brought a straight sex case, I'm male, and they made fun of me based on the fact that I wasn't male enough for them, for this workplace, whatever, then I think he would have had a better case, because there's a lot of case law out there that men can file claims in court and be successful for being made fun of because they're not masculine enough.
Right.
There's actually a case involving the Azteca restaurants where the male employee prevailed, and it wasn't a sexual orientation case, it was just a plain sex case because he was made fun of for not being masculine enough.
It's funny, you would think that, for example, the Price Waterhouse case, where a female employee was judged insufficiently feminine,
right,
and successfully, sued about that. You'd think that it would transfer.
It should have.
Yeah.
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 And I don't know if the
But
lawyer.
the courts are just not that quick.
Well, I don't know if the lawyer brought the case just on sexual orientation in the Fred's appliance case, or whether the court just ignored that issue. I'm not exactly sure what happened, but I think if the case had been brought as a sex case too,
Right.
and proceeded further along in the system, I don't believe it was appealed after that. I would have liked to have seen it appealed, but it was not, as far as I know. They may have settled out of court, which often happens, and then we don't get the nice appeal that we need for those cases. But I think it would have been much more successful.
Yeah. Now, should a case like that be successful, would that then lead to a rewording of the law, or how does that?
It wouldn't necessarily lead to a rewording of the law. We would just interpret the law as the higher court would have interpreted it. Say that Fred's appliance case would have gone to the Washington State Supreme Court, and the Supreme Court would have reversed that lower court's ruling. Then we would interpret the law as that Supreme Court decision interpreted it.
Okay, I see.
Yeah, which would have been nice, but.
Yeah. Okay, so you also mentioned disability issues related to medical procedures. How does that, explain to us how that applies?
Right. So, like I said before, disability is one of the biggest areas that we deal with, both disability discrimination, an employer doesn't want to hire somebody because that person is disabled, and reasonable accommodation issues, because the law requires employers to reasonably accommodate persons with disabilities. Which could require modification of the workplace, modification of workplace rules, schedule changes, and even time off. So if somebody is going through medical treatment because of gender identity issues, because they're transitioning, and they need time off because of surgery, for example, or they're getting used to a certain medication they're on, then that person should get that reasonable accommodation just like any other person with any other disability should get. And by disability, I mean recovery from surgery or the medication issues or something along those lines.
Now, is that still true? I mean, there were some recent changes to the Americans with Disabilities Act.
That's the good thing about being in Washington.
That it doesn't matter, that's at a state level?
Right.
Okay.
Right.
All right.
We're seeing a trend where the state law in Washington will protect persons more than they would be protected on the federal level.
Okay. I don't know if that's good or bad, but okay. So of all these different types of issues, hiring and firing, dress code, harassment, what do you see being the most frequent types of issues that you get, that you hear about?
The most common, I think, for employers to be confused about is the reasonable accommodation for disability.
Okay.
So let's say somebody is going through a transition and they need to schedule surgery and they need to take time off, and then there's time off from recovery, and perhaps when they get back to work they have restrictions such as lifting restrictions or the number of hours a day that they can work. So employers get pretty confused about that, and it is a confusing area of the law because you've got FMLA that comes into play too with certain employers who have over 50 employees. You've got the Washington Family Leave Act, which also comes into play. So it's an intersection of federal and a couple different state laws. So it can get pretty confusing for employers.
Sure.
So the advice I give to people is to keep clear lines of communication open both ways.
Okay.
So as soon as you know that you're going to be off of work or that you'll need reasonable accommodation, let your employer know about that. They don't need to know the details of your medical condition, but they do need to know how it's going to affect your job. So that they can provide you with that reasonable accommodation, start that dialogue going. And then as soon as you know how long you're going to be off of work, you need to let your employer know that so that they can make plans and plan for your comeback. So a lot of employers and employees get bogged down in when is the person coming back? And they don't know when you're coming back, and the person's not saying when they're coming back, and then the employer says, well, they're not back to work. What do I do? Do I fire them? What do I
Right.
So it's a very confusing issue for a lot of employers. So clear communication. Doctor's notes are very helpful.
Okay.
Presenting doctor's notes to your employer so that they have that official medical record that you need reasonable accommodation.
Right.
And then just keeping in communication with your employer about how long you're going to be gone, when you're going to be coming back, and what restrictions you might have once you return. So that will be very helpful in helping that process along.
Okay.
And then I think people being fired is the next biggest issue.
Okay.
For their protected class, and that runs the gamut of protected classes.
Right.
But they find out what your religion is, they find out what your gender identity is, or they find out that you're a person with a disability. So the next thing you know, you're facing some sort of disciplinary issue, and then you're out the door. Well, again, if you have that comparative information about, well, my coworker who's not in my protected class also did the same thing, and they were given a second chance. They were written up. They were not fired. Mm-hmm. So we see that a lot. The one person being booted out the door, whereas somebody else is able to get away with the same thing and stay.
Right. Well, so I imagine the difficult thing with laws like this is, being able to establish that, the firing or the failure to hire or whatever it is was in fact, motivated by, some sort of prejudice.
Right. And that is difficult.
Yeah.
Because the complaining party or the plaintiff in a lawsuit has the burden of proof to prove that they were discriminated against, that the employer violated the law. The employer never has the burden to prove that they were not discriminating. The burden of proof is always going to be on the person bringing the claim. And that is by a preponderance of the evidence, and that's basically over 50% of the evidence has to be in the employee's favor. And that's not as easy as it sounds.
I would imagine it takes a lot of documentation on the part of the plaintiff.
It takes a lot of documentation. It sometimes takes witnesses. So these are things we do during an investigation. So let me back up a step. So somebody who believes that they've been discriminated against in one of those areas that we cover based on a protected class files a complaint with us, and they can do so online, or they can do so by calling us and having us fill out or send them a complaint form to fill out.
Right.
Once we get that complaint form back from the person, we give that to our intake unit who evaluates it for jurisdictional criteria, makes sure that it's something in an area that we can handle, refers them to another agency if that's appropriate. But in an investigation, what happens is the responding party will often have the opportunity to respond.
Right.
And they will do so by sending in documents, giving us witness statements, and giving us basically their version of events.
Okay.
And once that occurs, the complaining party will then have the opportunity to review that. They will review that verbally during an interview with the investigator.
Okay.
And they will have the opportunity to present evidence that what the employer is saying is not true, that it actually didn't happen that way.
Okay.
So often the employer will come up with what's called a legitimate non-discriminatory reason for their actions. So I wasn't really discriminating against this person. What happened was they had performance issues that had to be addressed. So they will come up with a reason for doing what they did.
Right.
And then it's the burden on the employee to show, well, really, I didn't do that. That's not true. Or so-and-so also did that, but wasn't treated the same way I was. They were treated more favorably. Or actually, the reason is not what the employer is saying. It really was discriminatory. So there are ways in which they can prove that, one of which is through documentation, and we will look at documents.
Right.
Sometimes we will go to the site and do a site visit to see, especially in a reasonable accommodation case.
Right.
We'll do a site visit. And we'll also talk to witnesses. And that's where things get kind of tough, because often the witnesses are still employees of that organization.
Yeah.
And they're afraid of losing their job.
Sure.
So often we will have complaining parties be very excited about a potential witness.
Right.
And they're sure that this person is going to bolster their story, that they're going to back them up on every count. And then, of course, when we call that person, they're often reluctant to do so, or have a different story, or actually come up with a different scenario altogether. We had a sexual harassment case where a man insisted that he'd been sexually harassed by his female coworkers. And his witnesses were definitely going to back up his story to show that, yes, this happened.
Right.
And when the witnesses were contacted and interviewed, the witnesses actually revealed that it was the complaining party who was the sexual harasser, was actually doing the sexual harassing of the women in the workplace. So often it's the witness interviews that will make or break a case.
Yeah.
So we'll look at the witness interviews, and then once we have all of that information, all of that factual information we need, we will apply those facts to the law to determine whether or not the employer violated the law, whether or not there's enough evidence to show that that occurred.
Okay. And then
what will happen is we will try and settle the case.
right.
So we are often very successful in settling a case, and we can do that very early on in the process when somebody first files. And sometimes employers or places of public accommodation or housing providers are very anxious to just get the process over with, to not have to involve and pay their attorneys.
Right.
So they're willing to, set forth a settlement offer of a few $1,000s just to have it done. We often refer to that as a nuisance settlement. They just don't want to bother with the case.
Right.
They're willing to give a few $1,000s to have the person go away.
Okay.
And then often when we find that there is evidence to show discrimination occurred, we will let the employer or the place of public accommodation know this, and then that often inspires them to start thinking about settling the case. So we can actually settle some cases for quite a substantial amount of money if we've got the evidence to back up that kind of settlement. So unfortunately, there are those types of places or employers who refuse to believe they've done anything wrong, refuse to learn from their mistakes, and get entrenched in their position and refuse to settle.
Right.
So if that occurs and we've made those settlement attempts and they have fallen through, then the case goes to our Assistant Attorney General to actually prosecute in administrative court.
Okay. And if that is successful, then the plaintiff gets a monetary settlement?
Usually it's a monetary settlement. There are other types of settlements that can occur. The person can go back to work. There can be modifications to the job site in the case of a reasonable accommodation issue. They can get back pay. They can be promoted if it's a promotion case, things like that. However, if things have gotten that far, usually the person does not want to go back to work, and the employer does not want the person back at the workplace. So it's generally going to be a monetary settlement. We also try and do policy modification clauses in our settlement agreements, which says that you have to put in place a non-discrimination policy, or you have to put in place a reasonable accommodation policy, or you have to put a sign in your window saying that, yes, you will accept service animals at this location. Service animals are allowed to come in. We also do training requirements in our settlement agreements a lot. The employer or place of public accommodation or housing provider has to undergo training in the law against discrimination, particularly in an area. And we've done a lot of these regarding the bathroom issues with transgender individuals. Sometimes it is really a case of people don't know. People don't know the law, they're confused, they don't understand, and they need training. They need someone to come in and explain what the law is and how it impacts their organization and what they need to do to comply. So we'll often do training as part of the settlement.
Okay. So it sounds like this is a process that could take a long time.
Yes.
What do you do if a plaintiff doesn't want to invest that kind of time? Are there? Yeah,
there are options. So in an employment case, a complaining party or a plaintiff can also go to the EEOC, which is the Equal Employment Opportunity Commission, which is our federal counterpart in employment issues. They're not much faster, though. So they also have the opportunity to sue in state or federal court.
Okay.
So in order to sue in federal court, they need to file with the EEOC and then get what's called a right to sue letter from the EEOC, which will then give them permission to sue in federal court.
Okay.
If their lawyer decides that they need to sue in state court, they can just proceed immediately to state court. So that's always, court is always an option for people. If they don't like the process or they don't like the way the investigation's going,
Right.
or even after the investigation is done and the case is closed, a person can always sue in court as long as they're within those statute of limitations, which is generally going to be about 3 years. 3 years.
Okay. Now, what else can a person do if they feel they've been discriminated against, if they're not prepared to, you know, take it, you know, all the way to court? Is there, for example, can they simply, like, file, like, just some documentation, like, in the hopes that perhaps if this happens to somebody else, there'll be, you know, there'll be some sort of history attached to that?
I'll be honest, if somebody wants to just put it on the record that something is going on, they can call and talk to one of our intake investigators about the situation and then make the decision that they don't want to proceed.
Right.
But we get so many calls and we talk to so many people about so many different issues. The issue may not be remembered. So
Okay.
if someone else from that same employer calls back, you know, 2 years later regarding a similar issue, we may not remember that that original person called. So we may not recognize that there's a pattern. So if somebody's really concerned about getting something on the record and making sure that it is in our database where it's easily recognizable as a potential pattern of discrimination perpetrated by a particular employer, they really need to file a complaint.
Okay.
Yeah, and if they don't file a complaint, of course, that's their decision to do so, and they're right not to have to go through that process. But they need to know that there may not be any recourse or repercussions.
But if they do file a complaint, they have the option to, you know, not necessarily take it all the way to court.
Yes, they can, if they decide they don't want to go through the process, if it's too emotionally draining for them, which sometimes it can be to relive, especially a harassment situation, for example, may not be emotionally or mentally healthy for them to go through that, they can withdraw at any point.
Okay, all right. What do you find have been the biggest obstacles? What do you think the main factors are that would affect a person? Like, I mean, as you said, it may be too emotionally draining, or they may simply want to forget it and move on. What other obstacles do you find in trying to apply the law against discrimination?
So to specific cases, the obstacles would be probably the fact that often the employer has all of the documentation, and we don't know necessarily that an employer may be holding something back or may have destroyed something.
Okay.
We're hoping that doesn't happen very often, and I don't think most employers would do that,
Right.
but there are going to be those situations in which it happens. The other are the witness issues that I mentioned before, where witnesses might be reluctant to come forward with all the information they have. More systemically, I think the biggest hurdles that we've had to overcome, the economy. Back in 2008 to 2010, our agency was cut quite drastically. As you mentioned before, the sexual orientation and gender identity was added to our statute in 2006. We didn't do rulemaking until much later. That was the reason for it. And a lot of people were unhappy, but we just didn't have the staff or resources to do rulemaking until after the economic issues were over.
Plus, I imagine in a bad economy, people are less likely to complain and rock the boat,
Yes.
you know, fearing job loss and so forth.
Right.
And of course, for GLBTQ people, there's that added layer of they may be afraid of being outed.
Absolutely.
You know, if they pursue a case. But we're just about out of time. So, what else would you like our viewers to know about the HRC or the law?
Well, I mentioned the federal issues that are going on right now, and we've seen with the current administration that a lot of those protections, especially for, in general, civil rights in general protections, but especially for the LGBTQ community, they're being rolled back. And we've seen those rollbacks. Department of Education, for example, is rolling back protections for students. On the other hand, the EEOC is continuing to pursue sexual orientation, gender identity cases under Title VII. So there's a lot of confusion about what's going on the federal level. A lot of different things happening. We don't know what's going to happen next, but we do know it's probably not good for communities who are already at risk. But I want people to know that Washington does still have those protections. So even if the federal government rolls those protections back, Washington is not. Washington is still going to protect persons' civil rights.
Okay.
So I want people to know that.
All right.
And definitely people who believe that they've been discriminated against should give us a call or go to our website and file a complaint.
Okay. Laura Lindstrand, Policy Analyst for the Human Rights Commission, thank you very much for being with us tonight. I'm Luke Miller, and thank you for joining us on Tea Time in Olympia.